trading collectibles meeting cryptocurrency. And it's really just, a new medium for obtaining collectibles. So, I guess, to your question about, could college athletes get in the space? I think it's very possible. I think it goes back to, once again, the general notion of, if you're an agent or you're a brand manager representing a college athlete, what trademarks do you want to register, so that way you could use that as the basis, as the source identification under the realm of trademarks, to help promote a specific NFT platform that an athlete could potentially dive into. What companies do you want to work with to develop this NFT platform? Do you want to do a homegrown service using your own AI, or do you want to work with the likes of Dapper Lab? I guess one thing to bear in mind is, companies like Panini have already gone into the space of doing college athletic collectibles, if you will, by doing their own version of trading cards. So I guess this is just an extension of that. It's fairly exciting. I think, a lot of examples of, athletes getting into the NFT space on their own is a great example. Actually, ironically, one perfect example is Chris's client, Rojo, Ronald Jones, did an NFT collection right after winning the Super Bowl. And so for me, that's a great case study of somebody, an individual athlete, marketing off their success and doing something like that. So imagine if, imagine if somebody like Trevor Lawrence, if you will, if he were still playing in the NCAA, did something like that, where he wins a national championship, or any college athlete wins a national championship, and they launch an NFT platform to commemorate their win. So I think it's an open playing field. It's ripe for competition and opportunities. And it's really just a matter of, people buying in on it. NFTs seem to have their ebb and flow, like cryptocurrency, generally speaking, but it is a very exciting time.
I'm sorry, I apologize.
No, go ahead, Chris.
Okay. Yeah, so my background, I'm an attorney, obviously, but I was blessed. I grew up on a dirt road, on a dirt driveway in Pennsylvania, an hour west from Philadelphia, and God led me towards an amazing man named Lloyd Remick, who will always be my professional father, will always be my mentor. And Lloyd was an agent who'd been in football in the 80s and 90s, had gotten out of it, was more into to entertainment. And he took a very raw 23-year-old version of myself off the street and gave me an internship. I worked for free for 3 years, and I learned a ton. And he was 65, and I always have a debt of gratitude. And to anyone in the audience that has aspirations of doing this sort of work, find a mentor and work as hard as you can. And even if you have to work for free or what, anything just to get on, the knowledge is more valuable than compensation. You'll find part-time gigs to make money. I've worked every crazy job under the sun to make ends meet. But I bring that up because from 2003 to 2008, my practice was exclusively music for the most part. And then I transitioned, expanded into sports, and things grew. But in New Year's Eve day of this past year, I got a call from a friend of mine who had managed some music producers I represented years ago. And he said to me, "Hey, I haven't talked to you in a long time, but I need you to look over an agreement where there's basically, I'm going to be paying a producer for one beat. And we're going to marry it to a digital art installation, and we're going to auction it." And I said, I don't know what you just said, man, but but I know how to help you get rights to music. And I followed it, and it was with a very well-known global, icon in the EDM space. And it went for multiple millions. And I was like, wow. And it just kind of sat back in my head. And then we were in a staff meeting, and Matt Steinberg, who's our senior director of strategy, said, "Hey, you guys see what's going on with NBA Top Shot?" And I was like, wow. And a light bulb went off. And I called my friend who had called me about the other NFT situation before I knew what NFTs were. And I said, "Hey, could we do what you did and marry it with sports?" And he said, "Absolutely." And that's how the Museum of Mahomes came to be, that we do with Maker's Place. So 15 days from that call to 15 days later, we did Museum of Mahomes that benefited the 15 Mahomes Foundation. obviously did 7 figures, did very well. And then we did the first ever rookie card NFT with Jerry Judy. We did Tony mentioned the Ronald Jones World Championship celebration ring NFT. And we have some more coming out. We'll have one coming out here after the college season with Malik Willis from Liberty quarterback, who represent NIL. And, the long story short about that is we live in a society where we've always collected things of value. You look at the traditional art world, things like that, Sotheby's, you've always had valuables, things like that. Obviously, during the pandemic, the trading card world really kicked in again. Sports memorabilia has always been collected well. What I like about the NFT space is that for the first time, I think it's given athletes an intellectual property for beyond their playing years. Essentially, the professional sports is a service business. It doesn't make money in your sleep as an athlete or an athlete representative. With NFTs, when they resell, the owner gets 10% of the resale. That's part of the technology. So that's perpetual. So Sterling Mahomes is, not 1 year old yet, but I pray that the Museum of Mahomes will provide opportunities for Sterling's grandchildren one day. At the end of the day, it's backed up by a blockchain. A blockchain is a technology. You can think of it as a large database that tracks the buying and the selling. NFTs can be purchased with any method of payment. Obviously, cryptocurrency is growing in buying power, but a lot of the NFTs that we've done, and we partner with Bitsky for Ronald and Jerry and kind of moving forward. But most of them are purchased in cash or credit card, and someone that produces NFT with a physical component. So when you buy any of the NFTs that we've done with Ronald or Jerry, that are cards or that are jerseys, you also receive a physically signed, personalized card or jersey. So what we're trying to do in the NFT space is take the 600,000 registered sports collectors in the United States and transition them to the digital planet, where traditional collectors can get the physical in hand, also get the digital, so kind of 2-for-1 value, and then vice versa. But I would strongly suggest anyone to pay a lot of attention to the NFT market, because at the end of the day, our entire world is moving digital, and collectibles will continue to be there too.
You guys have anything to add before we pivot to our third topic?
No, only to say that I think that the point, or the protection of the underlying artwork, and making sure that a contract is in place that does what Chris said, and that is allows the original owner to continue with that revenue stream, is important. From a copyright perspective, again, as NFTs are transferred and different people purchase them, that they're buying a block on the blockchain, but they're not buying the copyright, right? And so what is important is to have an agreement that allows for the original, if that's the intent, which as certainly as the IP holder, you would want it to be, to be able to actually continue to enjoy that revenue stream as the product is sold through various consumers.
Yeah, so I probably know the least about NFTs of everyone in the room and also zooming in. But I do feel like it is going to be a big deal in sports, primarily for the reasons of it can allow for an increase in fan engagement. So I learned about NFTs, maybe like most others, but I was just listening to a podcast some months ago, and Mark Cuban was the one who was really talking about it in terms of creating NFTs to allow for in-game experiences, to draw a crowd to a game there. And so I can tell you that there's already conversations on the collegiate level in terms of utilizing that kind of an opportunity there on campus there. And so
one sort of non-legal but interesting point, what I've often tried to get my head around with the NFTs is, okay, what do you do with it? What do you have? You've got something on the blockchain, you can look at it on your phone, you can look at it on your computer, but as I'm learning more about it, the idea is that going forward, people may display these on screens, right? And so there is a recent deal in the process of being done that will transfer iconic posters from the 80s by an artist, Kostakos, into an NFT format. Now, there are some rights clearance issues, and or you can be able to go back and clear the right publicity and everything that we need to put out to repurpose these old posters. But with the idea of having something like that, and then having these displayed in a home or a business on a screen, all of a sudden you can start kind of seeing how maybe this does come to life, and not just something that you would look at on your phone and say that's cool. And go on and check your emails.
Sure, seems like a win-win for everybody. It seems that the agents are going to make money, IP lawyers are going to make money, and hopefully the athletes are going to be able to have these things carry on for a long period of time.
I just want to add one final thing to that. So I think our speaker there just really hit on kind of the next wave. The biggest disconnect currently with sports collectors is display of the NFT. So in an office, it's kind of hard to see, but this is a painting. This Justin Foy is an artist that does a bunch of stuff. I don't know why you can see that, but anyway, it's a really well done painting of Patrick, and it's framed and it's hung on a wall and it's displayed. When we did the Museum of Mahomes, the winner of the 1-of-1 is part of the winning bid. You got a 55-inch LED screen that went with it that showcased, you could show the NFT on. So now it becomes something you can actually enjoy and be tangible. If you've ever someone's home and they have a LED picture frame that shows like digital pictures kind of on a scroll, that's really the first, advent of NFT, digital asset, digital collectible display. Where we're going to be moving is we're going to be moving in a world where I want you to almost think about like Napster and music and Apple. At the end of the day, Apple really went out there because people consumed their music with. First was an iPod, now it's Apple Music and AirPods and things like that. NFTs are going to be consumed in LED digital format where it's like on a frame. NFTs are going to be consumed on devices where that project vertically. So like that Ronald Jones World Championship ring that can be displayed and admired. And then in the hologram world, where literally someone will be able to buy a hologram NFT that just like a statue would be displayed in a foyer is vertical. So that, those sort of technologies are really going to spruce things up. Just putting the core legal hat back on for a second, the best advice I could give anybody that represents talent at the pro level or the NIL level is don't use marks, don't use anything. So a school, a conference, a league, a team, anything. Make much about the moment, make as much about the athlete in that moment as possible, and really double down on great art, really double down on unique colorways, things like that bring it to life. And if you do that, you're going to find a really rabid consumer base in the art world. You also run astray of any legal issues.
Thank you. All right, so I'm going to shift the conversation just a little bit. Professional sports has long been a challenging space for female athletes to sort of get the same attention and the same salary attractions and the same other sort of, monetization efforts that go around with that. So I'm curious if the things we've been talking about, the NIL rights, the NFTs, the way that this is expanding to college athletes, how are women athletes brought into that conversation?
Sure, so I can talk a little bit about that. So you're seeing a lot of issues in the female student athlete space because you're seeing a large disparity between the deals that college female athletes are getting in comparison to the deals that male college athletes are getting. You're seeing the large deals go to the quarterbacks or the basketball players on, the top 10 March Madness teams versus, female athletes not getting the same attention and thereby not getting the same, payment in exchange for their status as a college athlete. It's really not clear how this is going to be addressed, or if this is going to be addressed. I know that, there are some schools and school policies really thinking about this, thinking about, the environment of their school and the environment of their school sports, and wanting to create a space in which both the female and the male athletes are equally valued in that space. But we haven't really seen a lot coming out as of yet, in terms of how this is going to be handled, either at the NCAA level, at the state level, at the school level, or even possibly at the federal level.
Yeah, I can just chime in from the NCAA's perspective. I mean, this gender kind of making sure that basically equal opportunities were being provided to both male and female student athletes was something big that we thought about as we were going through the kind of the 2-year process of kind of reviewing the rules and coming up with those we were thinking about. The problem is you just kind of run into just basically kind of just case law, state rules, and everything else that basically make it a little bit hard from that perspective to put rules in place that may favor one gender over another without basically running into putting yourself into a position where you're going to face litigation about that rule. So, I mean, our perspective from an NCAA perspective was basically whatever rule we were going to come up with was not going to basically lean one way or the other from that opportunity to give every single both female and male athletes the same opportunities. But the issue was just the marketplace in and of itself was going to basically kind of overall determine where that pendulum was going to swing based upon what the demand was for whatever was out there from an NIL perspective. And that's kind of how we had to leave it in order to do it that way. So,
at SSC, we're very much, united against inequality. It's something that we started making very visible a year ago, and something we continue daily. And there's no greater disparity, unfortunately, in society than the pay of men and women in professional sports. Honestly, that gap is closing, but it's not closing, can never close fast enough. One of my greatest joys in life right now is being a volunteer on the executive committee of this NWSL team in Kansas City called KC Woso, that tomorrow actually announces its new name, which is exciting. And it's really opened my eyes to a ton of things. In growing the company at SSC since being named CEO, and growing our staff too. A large number of our key executives are female. And I've heard horror stories from them about the workplace and environment, and it at times just makes it just sad. The good news is I think there's more going on in society than ever to help improve those situations, and NIL has been strong with that. At the end of the day, you have affinity schools where we're very fortunate. We're with Spencer Rattler at Oklahoma, and Oklahoma softball is as popular as Oklahoma men's sports. And you're seeing a lot of the softball players at the University of Oklahoma, getting NIL deals and things like that. We just did a deal recently where a player, male player, predominant, very well compensated deal, and Olivia Dunn also has an endorsement. Olivia Dunn's a gymnast with LSU, and the compensation was the same, and that brought joy to my heart. So I think there are good things that are happening in society. Can't happen fast enough. But NIL is another vehicle to hopefully bring equality to things.
Yeah, I think you're seeing this, across sports, even outside of the college athlete NIL space. You have the U.S. Women's Soccer Federation, really, dealing with this on a very large scale. But then, you have movements being made in connection with the Olympics. You saw Simone Biles really paving the way for female gymnasts. And I think as a result of that, you probably saw a lot of female NIL gymnast deals coming out of the spotlight that the Olympics really gave to female athletes. And so I think we're going to see, a lot more developing in this space. One thing that schools at least have been thinking about in terms of, and hoping to more equitize the spaces, arranging deals for their female teams, maybe, a little bit more than they do for the male athletes. But, it's really yet to be seen whether or not this I think as this continues to gain traction, you're going to see, hopefully, as Chris mentioned, more females, making more strides in this space as well.
I think related to that as well, and that's a good point, is the conversations that are going on campus about, as a matter of policy, are we going to allow for the mechanism of group licensing? And so to the extent that a licensee or a sponsor can come in and in expeditiously clear rights to a collective group of players, all of a sudden it becomes, it facilitates the ability to do a deal across women's volleyball or softball. And so, in addition to, looking at, okay, here are the big marketable elite athletes. Now, there are opportunities for, these kinds of collective deals. And historically, you think about group licensing for trading cards, the long lost EA Sports video game that will probably be coming back. But, there's having a mechanism to sort of equalize the process and allow a more fulsome involvement for college athletes across the board, I think could benefit, certainly female athletes, but all other athletes that are not that are part of the team, but not necessarily the top marquee athletes.
And just to give you an example of where we're at today, since July 1, once NIL became a thing, at least on our campus, I think I mentioned it, we have about 200 NIL transactions amongst our athletes that have been reported to us that they have to do. Of those 200, it's about a third where it's females that are getting involved with those transactions. So there's some opportunities there, but in terms of the disparity of the dollar amount to some of those deals, it's by far been seen on the male side for sure. So we hope as this progresses that there's an opportunity for growth there.
Gang, just real fast, empowered, in control, and authentic. The great thing about this is empowered. Everyone has an opportunity now in the NIL space. In control, social media, Reels, TikTok, things like that are giving athletes of, men and women, all sorts of opportunities to create their own content that's authentic to them, content that's driven towards, their fan base or towards an affinity base or an alumni base or whatever. So the reality of it is the modern athlete is going to become as much of a content creator as he or she is focused on their position. That's just going to continue to drive their demand for them. And that is going to help, really start to close that gap.
All right, now, so we're going to pivot to our maybe last topic that we have time for today. It's the intersection of the two big A words, amateurism and antitrust. Now, the Supreme Court spoke on this in June this year, right before we had name, image, and likeness. And so I think there's a lot of confusion about this, because the Ninth Circuit said in O'Bannon that antitrust law doesn't give you a right to your name, image, and likeness. And the result of that was California starting and then all these states passing state laws to allow you to do your name, image, and likeness. But I think the elephant in the room is what about pay for play, and what is the consequence of these cases? If you read Kavanaugh's concurrence, and he's just one of 9, it seems like pay for play will be a reality tomorrow. If you ask universities and NCAA, I think they would say not so fast, and that the current model works really well in a lot of different ways, and we should preserve it as much as possible. And it has nothing really to do with athletes getting endorsements. So maybe the lawyers could speak a little bit to antitrust issues, and maybe even this upcoming case that we have that's pending, the House case, in which it's a class action of college athletes trying to get name, image, and likeness proceeds that they lost based on the NCAA's rule pre-July 1, 2021. So you guys jump in and let me know what your thoughts on this.
It's a great question. Just briefly for those that aren't familiar with this, the reason why this is such a great panel today, there are probably 3 cases that people should be paying attention to. There's a class action case that was started by Villanova students that's still kicking around in Pennsylvania. There's the House case, which is a swimmer suing to kind of change the definition of name, image, and likeness, essentially to include, at a high level, to change our definition of it, right? Why aren't athletes right now compensated for, maybe part of a television deal, right? Aren't TV using their likenesses and their names in some way, right? Why isn't that included in this movement? And then last but not least, what you mentioned, right? NCAA versus Alston. We have 3 mega cases that might be decided, at least in some way, shape, or form, in like a 3-year period, which is kind of unheard of. So the world of NIL is certainly being put on its head. So you talked about Kavanaugh's concurring opinion. Just really important, just as a kind of brief history lesson. We'll say 40 years ago, right around there, NCAA versus Board of Regents was decided. It's the last time the Supreme Court took a college sports case. That was a case that turned college football, specifically from maybe $1 million business, tens of millions, maybe 100 million, into a business that's much closer to, $1 billion business. That really turned television contracts on their head. And then you have Kavanaugh's concurring opinion, which used athletes in the same sentence or same paragraph as employees. So, when the Supreme Court touches upon these cases, they happened 40 years ago. It changed the world of college sports as we know it. And then wouldn't you know, right, within a couple months, right about 3-4 months, the NLRB, which I don't know if we'll have time to talk about it, issued an opinion or a memo that essentially said student athletes are akin to employees. So we'll see if any of these private institutions want to challenge that and challenge the ability to be able to unionize. But that world is certainly being turned on its head. So from an antitrust level, from a labor law level, everything that we know about college sports is changing. So, certainly different questions, name, image, and likeness versus the ability to unionize. But, Kavanaugh, I think, sent us down that path. I don't think it's that crazy to call student athletes employees in the next, 5-10 years. I think we're certainly trending in that direction.
And to Dan's point, I think one really important sentence in Kavanaugh's concurrence was that the NCAA was not above the law. And that's really important to stress because the NCAA has, sorry, I don't mean to make it sound so derogatory, but I have an opinion that the NCAA has abused and, misused the ability of college athletes to the point that it's acted almost as a quasi cartel. So it gets to the point where you have to ask yourself, how long is the NCAA eventually going to stand on this whole argument that they are an amateur league when they reap in millions and millions and millions of dollars just from March Madness advertising alone? And I think that the O'Bannon case was essentially the setup, the domino effect that led all the way to what Alston is and is really going to change the landscape for NIL, college athletes, college athletics being a professional league as opposed to an amateur league. I mean, the conversation will go on, but this is just the beginning of something pretty big.
Yeah, so I'll kind of give in my opinion here.
Curtis is like, I guess I have to chime in here.
So, because
Tony
some of
did say it was a cartel. So I mean,
yeah. Let me just put it this way. Yeah, Kavanaugh's language definitely coming off the top rope on an already beat down. So I get it and respect it and understand it. I would not describe the NCAA and its member institutions as a cartel, basically doing the same things in the same way that you would describe a criminal enterprise and what they do. So I do disagree with that language and how you basically describe the NCAA from that perspective. I'll say one thing. I'll just say this: if Kavanaugh's dissent aside, if you really look at it, what Alston said, it basically was dealing with those specific sports that were dealing with the Alston case, but it did basically put our rules in a different place than we currently were. But it wasn't a prohibition against the NCAA's ability to make rules and to basically have a rulemaking process. It basically said that our rules were now basically subject to the rule of reason, and that we basically had to have, a good, rationale, reasons to basically have the restrictions that we had in place that were consistent with antitrust law. And we just couldn't just rely on basically kind of us basically being the arbiter and basically the people that oversee college athletics to do that anymore, just that rationale. We just had a reason. So there's still rules that we can have in place. There's still rules that we can make, and there's still restrictions we can put in an antitrust space. They're just subject to basically the rule of reason now, whereas before they may not have been. Look at previous case law and how we've been before. So I think that's one. And so despite, I get it. It was going to be a change, and I'm not acknowledging the change. I think we basically be fools to not do so, but I don't think it is the be all end all. And as if you kind of look at some of the rhetoric that came out of that, you would think that the NCAA and its member institutions basically going to just shut down, just basically not to do anything. I don't think that's the case. I think basically there'll be a change. I think that would be the reason we have to kind of basically look at our rules and have our reasons and the rationales and make sure they're not restrictive in how they're basically coming out. But I don't think that you'll basically see a complete prohibition against the NCAA's ability to make rules. And the other thing I would just basically say is, we're just basically, I think the biggest thing for this, I think we'll continue to have this until Congress really kind of steps in and basically puts a little bit of consistency from an NIL perspective, from a labor perspective, and from every place that you want to be. Even if you listen to some of the folks in Congress and where they want to be, I don't think they're quite on the edge of where some people may be, some of the detractors in NCAA may be even from an employment standpoint, even from an NIL standpoint. I think they want consistency with NIL, and I think they do want to kind of figure out what they want to do with college athletics and answer that employment question. And we're hoping that they do so and hopefully help that way. So again, I'll kind of stop there because I can't really go get, my full opinion on where we should be at house and kind of our other things that we're pending litigation I'm not going to get into, but I think that's kind of the perspective that the NCAA will probably bring a different perspective on kind of how we're looked at from that perspective.
Can I add something quick just to Curtis's point? I mean, I think the concurring opinion, honestly, from Kavanaugh put the NCAA in kind of a tough spot, and Curtis doesn't have to say it, but when you say the NCAA is not above the law, you're sending a message that it's we're watching what the NCAA does. So if you just watch the NIL landscape, I think the NCAA maybe, and Curtis, I'm not asking you to say anything, but it seems like the NCAA maybe had a plan to be a little bit more involved in the NIL movement, maybe as a gatekeeper or kind of a policing force. And then, we don't really have something like that now. So if Congress does step in, be it a federal bill in the next couple months, I feel like that would be fantastic. But I think as of now, in these first 100 days of this NIL era, I think schools are kind of policing themselves. So I don't know if that's necessarily good or bad, but I think that would be helpful. I do.
I would definitely agree with that. I mean, the change for me and what happened there with what the decision just did overall was basically take our more centralized way of rulemaking, and you'll probably see not just with this rule, but a lot of rules moving forward, just being more decentralized and where you want to be. And so, although the NCAA from that national perspective may not be able to put in a national rule of prohibitions against there, if you look at the opinion, there's nothing that says that it can't be more regionalized pieces where you have those same restrictions in more regionalized places where you basically have schools individually making those decisions to do that, or basically conferences basically having different rules from different regions in that standpoint too. So I think if anything that you'll see from that standpoint, you may not see the kind of national kind of reach where you want to go from that standpoint, but I don't think anything in that decision, if you look at it, and I don't think anything from an antitrust law perspective will stop conferences or individual schools from putting some of the similar restrictions that can maybe not be able to put in a national perspective, but maybe able to be put at a more local or regionalized way that basically still gives student athletes and consumers and the marketplace the same choices that they want to make to say, hey, I don't want to be here, I want to go there and do that. But that doesn't mean that some of those restrictions are just going to basically poof and just go away. So.
Do you all think part of the issue is just that you have two essentially revenue sports, or even 1.5, that are billion-dollar businesses, and then you have the rest of the NCAA model working with all the non-revenue sports? And to what extent do you all see the future as being something that splits those things apart, or still tries to hold them all together? And even with the schools, you've got 1,200 schools, and you've got really 60 to 80 schools making mega bucks on all of this. And so to what extent do you see, the problem being you're trying to do a one-size-fits-all model with lots of different schools and different interests?
Yeah, that's a tough question to answer from my perspective on that. I don't think it's any secret in the world that basically the revenue generation in college sports is going to be with men's basketball and with football. And that basically men's basketball and football basically funds the remainder of the sports and basically kind of lifts up the rest of the pieces of it. So I don't really have an opinion on where it will go, but when I'm asking this question, I'm basically saying I think people in society, especially in the U.S. in general, have to make a decision about what do they want out of college sports? Do you want it to just be something that's really focused in on men's basketball and football? Or do you want to basically have those opportunities in those other sports that are going to go out there? Because those sports have to be funded and they have to basically be, supported in some way, shape, or form. And the current model basically says that it's funded through how it's currently funded through those resources. If that changes, I think that's a decision that can be made, and I think it will adjust. But I think it will look vastly different if all of a sudden the focus is going to be on men's basketball and football. And I think that you'll see particularly some of those Olympic sports and some of those things that are going on that are low revenue. And I think it'd be particularly devastating to women's sports because those things are not revenue generating at this point. And then until they come to that point where they can be revenue generating, it would be hard to basically justify a business decision to fund those things if basically the focus is going to be on those two top primary.
So right now in college sports, right, and to Curtis's point, the money seems to flow kind of horizontally across sports programs. If football and basketball make the money, then schools are free to allocate that money across a number of different sports, and that's just the revenue model of sports for forever. But if and when, I don't know when it's going to happen, but when I'm saying that maybe athletes will be viewed as employees in the next 5 to 10 years, it's a little bit different. You had I don't know if anybody was paying attention, but right before the Pac-12 canceled their football season last year, and then they obviously came back, there was a number of students that put together kind of a coalition to strike against the Pac-12. And they said, as football players, we want money. We want the money to come down to us vertically. And that's kind of what would happen if student athletes were called employees and got the right to strike, and got the right to unionize. Money would flow vertically. So, it's an interesting question. Everybody likes NIL because you're creating a new stream of revenue, right? These third parties are paying athletes. But it's a little bit of a different slippery slope, right? Certainly athlete empowerment, you want athletes to make money, right? And a football player, he's got all the right in the world to say, I'm making the money for school, I should get paid that. But from an amateurism perspective, if you want to use that term, or just a traditional college sports perspective, that money, if it goes vertically, I don't know if you necessarily see all the other sports existing. And I'm not necessarily saying that's a good thing or a bad thing, but everyone likes NIL, and it passed unanimously on the left and the right because everyone's like, yeah, this isn't really disrupting what we know as college sports. But if you do have the money flow down vertically, that's going to be a very different world. So, that's when we're saying things are changing and trending towards that direction. That world doesn't really, maybe it's a good world, but that world doesn't really resemble the world of college sports that we know. So it's not doomsday. It's very different.
It remains to be seen to what extent antitrust law will really push that into the reality, or courts will do like they've done pre-Alston and Event and say, well, not so fast. So it'll be interesting. Anyone want to get the last word in? We're just about out of time. Does anybody have any final thoughts? It's been a fantastic conversation that's covered a lot of ground in a lot of different directions. I just want to give anybody a chance for a last word here from the panel.
I think a lot about the new opportunities that the NIL changing landscape is creating. And, right now there are uncertain times. It's currently the patchwork of state laws, university policies. It's a lot to navigate. And at the end of the day, the responsibility for that navigation falls on, guess who? The college athlete. And so I just think that as the process moves forward, and we're at a law school, education is key to all of this right now, because, whether it's selecting the right people to be around, the right representation, looking at the contract that you're entering into, and whether that is going to be a good thing, whether you're giving away the farm. There's so many things to think about. And I think that just, the importance of things like financial literacy programs, having access to good advisors. The student athlete, you can't do all of this yourself. And so to me, the challenge here is to be in a position to become knowledgeable, and then it becomes a great learning experience, and perhaps you can, make a few bucks as well.
That's great. Anybody else want to close us out?
Gang, I just want to say this. First of all, thank you again for the invitation to be a part of this. The reality of it is I think probably a lot of the folks in your organization and that are in attendance today are looking to represent athletes. And the great thing about the NIL space is that at least for me in my career, it was really hard to get in the door and then find clients and build and grow. The great thing about NIL is that, you may have some state registrations and things like that and compliance, but if you're someone that wants to represent athletes and you feel like you have some value that you can offer them now in forms of representation, whether it's finding some deals, whether it's helping improve their social media presence, whatever it is, you have the opportunity now to get your foot in the door and start to build your career So check your state laws, find out what the registration process is, make sure you're all set up with compliance, but take advantage of NIL to your wings and yourself and strut your stuff and help some people.
All right, let's give our panelists a round of applause.
Thank you, everybody near and far for coming. We will be having another conversation about NIL with a couple of law professors in a few weeks. Information will be sent out there right about that. So thank you guys again. Well done.
Thank you so much, everyone.
Thank you, guys.
Thank you. This is so great. Thank you. This is great. Thank you so much for coming and talking. It was wonderful. So thank you. Yeah, absolutely. Yeah. Did you get a chance to eat Chick-fil-A? Okay, yeah, make sure you do. Yeah, definitely. Yeah.